So what were the origins of the UNCITRAL model law? Well, I think they lie in the 15 years that follow the end of the First World War, starting in 1919 with the creation of the International Chamber of Commerce and its Court of Arbitration, when as the two Geneva Conventions, the Geneva Protocol of 1923, forced courts to decline jurisdiction over cases that were brought in breach of arbitration agreements. And in 1927, the Geneva Convention on the Recognition and Enforcement of Arbitration Awards provided a solid foundation for the enforcement of arbitration generally. This was all part of something which Arthur Nussbaum called the arbitration movement. He himself was something of a leader of it, being the editor of 3 issues of the German Yearbook of Commercial Arbitration. These brought together reports from various arbitration countries about the law and practice in the states concerned, and contained essays by Nussbaum himself, notably on what he considered this movement to be all about. Fascism, though, destroyed all that, and one has to really wait until the late 1950s and the New York Convention for any revival of interest in the improvement and unification of arbitration law. The New York Arbitration Conference, which led to the Convention on the Recognition of Arbitration Agreements and Awards, may have been more significant than the Convention itself, because it persuaded those involved that they could get together and discuss ways of improving and taking forward arbitration law and practice. And this was reflected in 1961 with the European Convention on International Arbitration, which was made in Geneva. But strangely, Switzerland and the United Kingdom, 2 of the 3 biggest countries in arbitration in Europe, declined to ratify the convention. Nevertheless, this agreement did contain provisions on appointing arbitrators, on the law governing the merits, on jurisdiction, and even trying to limit the scope of judicial review of arbitration awards. But the unification movement really hit the buffers in Strasbourg in 1964 with the Uniform Law Convention. This was basically an attempt to provide a single statute that everybody could adopt as their arbitration law. Far too many countries insisted on various opt-outs from the original draft, and ultimately only Belgium and Austria ever ratified the convention, and only Belgium ever enacted the resulting statute. It was time to think again. 1958 to 64 is an important period for the model law because it persuaded people involved in discussions about arbitration that they could get together and agree on ways of improving legislation, but at the same time appreciated that different countries would go in different directions. A model law rather than a convention might be the way forward. The 1970s saw the United Nations particularly concerned with the development of legal systems in second and third world countries. And this led in turn to their creation of the UNCITRAL rules of 1976, which are still the most popular rules for the conduct of ad hoc arbitrations. UNCITRAL was also tapping into something else that was going on. In 1969, the Swiss started off a period of reform of arbitration legislation that was to last much of the next 2 decades. England in 1979 reformed their law very slightly, but France completely overhauled their old Code Napoleon-based statute in 1980 and 1981. So the model law was tapping into 2 different strands of development. First one sees an improvement in the attitude towards arbitration of developing countries, perhaps typified by Kuwait's more constructive approach to the Amin oil arbitration in 1983, and at the same time a general interest in how to improve arbitration legislation worldwide. And it's against that background that Gerald Herman, who ran the UNCITRAL project, was able to put together in 1985 a fairly internationally accepted standard model law for arbitration, which countries could either adopt, amend, or just be influenced by. Thank you.